Ah, there you all are. Good afternoon, everybody from Risk Crew. I'm Nick Roberts. I'm a director here at Risk Crew, and welcome to, I think this is the sixth in our data protection webinar series. This webinar is focusing all about the EU decision on whether the UK's data protection regime is accurate. Sounds like fun, huh? So, well, thank you for your time this afternoon. I'm coming to you live from our office here in central London, about 400 yards south of Tower Bridge. We'll be joined shortly by my colleague, Andy. So we'd like to keep this as interactive as possible. So if you have any questions, if you please punch them into the sidebar, I'll keep an eye on them and weave them in where possible. But we will have a section at the end for Q&A. So yeah, keep your questions coming. Just I see from the audience that about half of you are what we call friends and family, people we've worked with or are working with currently. So welcome to you guys. For those of you that aren't familiar with Risk Crew, we're a London-based full-service information security consultancy and testing company. I don't want to make this a big sales pitch, so if you have a look at our website, riskcrew.com, you'll find full details of all of our services on our website. But why are we different? Well, we're absolutely passionate about delivering the best methodologies for each engagement that we work on. Of course, delivering the best quality and pragmatic deliverables, but also the way we engage with our clients. Information security can be a pretty complex and stuffy subject. So we really believe in knowledge and skills transfer when we're working with clients and complete customer satisfaction. And we're unique. We offer 100% satisfaction guarantee with all of our projects. If you're not happy, you don't pay. Nobody else does that. So let's have a look at who we are. I'm Nick Roberts. I've been with Risk Crew for, crikey, just over 5 years. And prior to that, I've been in information security for a total of 15 years. My experience is mainly on the GRC side of things. I'm more on the pre-sales, have a pre-sales role here at Risk Crew, and I'm also the account manager for our key clients. Andy, who will be joining in a second, he's most definitely one of our doers. Andy's one of our senior consultants. He heads up the data protection team, and he, like me, also has 15 years in this industry. So if you can contain your excitement, these are the topics that we will be covering in the next 20 minutes or so. So first, clarification on this decision that was due on the 31st of December on what the new UK data protection regime looks like and what data adequacy means to you, your organisation, and what implications it has, and what perhaps you may need to do to become and stay compliant with these new requirements. As I say, we will have some time at the end for Q&A, so keep those questions coming. So before Andy joins us and we get into the meat of this presentation, it's probably worth just having a quick look at where we are now. So as we're all aware, on May the 25th, 2018, GDPR came into European law. On that same date, the Data Protection Act 2018 came into law in the UK, and that was 99% based on GDPR. The extra 1% was a few UK-centric clauses in DPA 18. So since May 18 and all the way through transition last year, it's all been one happy family in the UK and Europe in terms of sharing and data flows. But as we know, on the 1st of January, we left the EU, we became a third country. And part of the changes, all of the changes when we exited was this question, did or does the UK recognise our data protection regime as adequate? It's all about adequacy. Are we deemed adequate? If we are, that harmony continues, nothing changes. But if we're not, then a lot of changes will occur. So at this point, I would like to bring in Andy. Andy, Mr. Whitaker, are you there, sir? Ah, there he is.
Nick. Yes.
Hey, Andy. Hey, Andy. How are you?
Oh, absolutely fine. Thank you very much, Nick.
So you are in our West Coast office in San Francisco, I believe.
Oh, if only, Nick. If only. No, I'm in deepest, darkest Essex.
Oh, you're in your home office in Colchester.
Indeed, I am.
Okay. All right. Okay. Andy, before you start, could you maybe give a quick introduction?
Certainly, yeah. Andy Whitaker. I'm sort of data protection specialist with Risk Group. I've got a long, sort of illustrious background in data protection and ISO 27001. Data protection officer for a number of clients. So I go around advising. It's basically a hands-on role. So I'm keep up to date, do an awful lot of research, try and keep ahead of what's going on to our clients.
Super. Okay. So Andy, I left this big question hanging about adequacy and the big decision that was going to be made on December 31st. I'll hand over to you to say, Andy, what was that decision?
Well, Nick, right, the suspense, the decision, everybody was waiting and waiting and waiting, and there was a big surprise. And that big surprise was there was no decision whatsoever.
Oh, no.
Basically, although it's not included in the UK-EU trade agreement, which was announced at the end of the year, there was also an ancillary agreement. And this is essentially a bridging agreement, which runs initially for 4 months, and it can be extended to 6. But it keeps all the data flows between the EU and the UK as normal, as though nothing's changed.
Okay, so that's the good news is nothing changes now. We can carry on exchanging data with to and from the EU.
Yeah.
But I guess the bad news is a decision will come in 6 months. And am I right in saying, Andy, if an actual decision isn't made in 6 months, we automatically default to a position of third country and are deemed non-adequate in terms of data protection?
Yeah, in the absence of an adequacy decision, we default to being a third country,
Right.
under GDPR terminology. Indeed, we do. Now, because of this, because the EU is not renowned for being speedy in its decisions, and also an adequacy is an unknown at this point, it'd be very prudent to prepare for a negative or a non-decision. Absolutely.
Okay.
You've got to prepare for this.
Okay, so you're going to now take us through all of the things that we need to consider and some of the things we may need to do in the event of no or a negative decision.
Absolutely, yeah. Brilliant. So let's look at this adequacy thing first and how adequacy is determined. It all starts by a proposal from the European Commission, which is sort of one half of the European Parliament. They effectively kick into life the European Data Protection Board, who are tasked with giving an assessment and a view of the UK's adequacy regarding its data protection laws and regime when compared to GDPR. So broadly speaking, is the UK data protection legislation meeting the same type of requirements as GDPR? So the European Data Protection Board will provide their opinion. if it's a good one, it'll get approval from the representatives of the EU countries, and these are the ministerial representatives. And then it'll be adopted into the EU sort of law, legislative working agreements by the European Commission. So that's how adequacies are determined and become effective. Now, what data protection adequacy would mean to your organization would depend very much on whether or not you are processing data with personally identifiable information of EU nationals or people residing within the EU. So if your data sets have that information in, then adequacy will mean quite a lot to you, because the EU would then consider UK data protection to be equivalent to GDPR. And broadly speaking, this means that no changes are required. So we don't have to go along updating all of our documentation, our notices, our contracts. Everything just carries on pretty much as it is. There are a couple of caveats to that, but to be honest, that basically everything just carries on. Now, if you don't process personally identifiable information of EU nationals, then it's probably got no sort of impacts or interest to your organization, what's going on in the EU. And I've seen this with some organizations which are very UK centric, but a large proportion of our clients have activities in the EU and are open to trade with the EU. So they need to be aware of this. So let's keep a few things in mind here. Now, the UK government's announcement on the extended period for data transfer, personal data transfers, was a surprise, and it was a surprise to just about everybody. And I found out about it by the ICO's response to the agreement, which is now on the ICO's website. It's actually not mentioned in the summary or the body of the EU-UK Trade and Cooperation Agreement.
This is that big 1,500-page document that came into play on the 1st of January.
Absolutely, yeah, that is that one, and I've actually read through it looking for any mention of this bridging agreement, which allows us to carry on with data transfers. Now, the other thing I found is a snappily titled thing called Title 3 Digital Trade, which you could find on page 116. And that's the bit, it has a couple of paragraphs in around data protection. So it's not a huge section at all. So it's if anybody's interested and wants to go and have a look and doesn't want to wade through all of the phishing stuff and the haulage stuff and everything else that's in there, page 116, there's a couple of pages there.
Sounds like good bedtime reading, Andy.
Well, I fell asleep several times. Now, an adequacy decision within 6 months is not guaranteed for a number of reasons. As I mentioned, the EU sometimes moves slowly when it's considering things, it's making decisions. And also the board of experts looking at this have a few things to consider, and it's a constantly changing landscape. So the things they'll be considering now will be slightly different to what they were considering a year ago or 2 years ago when other countries went through this process. So it's not guaranteed. And my gut feel is it's probably 50-50 at this stage. I really would not bet that an adequacy decision will be coming within those 6 months. In fact, I'd probably bet against it, but as I said, it's 50-50. And that's why I'm advocating that it's prudent to prepare for either no decision or a decision that goes against the UK. So if we assume that an adequacy decision is not in place in the 6 months, what does that mean? Well, it means that the UK becomes a third country under GDPR terminology. GDPR restrictions would then apply to EU personal data being transferred to the UK, because it would then become an international transfer. The data subjects would need to be aware that this international transfer was going to be taking place with their data. It required changes to privacy notices and processing contracts just to reflect the change in status of the UK, essentially being demoted to a third country. There's an interesting thing about representatives may need to be appointed in the EU. Now we'll cover that off in the next slide because it's an interesting topic and it could be quite an expensive one depending on the nature of processing that your organization does. Now, do you need a representative? And what I mean about this is that if your organization is based in the UK, it's solely based here and it has no branch office or any other sort of place over in the EU, but you offer goods or services to individuals in the European Union or EEA, or it has this ambiguous term, monitor the behavior of individuals in the EEA, but you're processing personally identified information of individuals within the European Union. Then your organization will need to comply with the GDPR requirements for that type of processing and appoint a representative for your organization within the EU.
So Andy, this representative is a physical, a person or a business, an organisation, maybe a law firm, based in the EU who is representing you. So it's a physical entity that you will need to appoint if this is applicable to you.
Yeah, it's a legal representative. So it could be an individual, or it's expected that normally it will be a company, because I expect specialist companies, probably law firms, will take this role, and they will represent you. You need to be represented to the governing bodies. We have our Information Commissioner's Office over here. They have similar ones in the EU territories. So their supervisory authorities are the ones that would be making calls to your representative. Now, you don't always need a representative, even though you're processing EU data. There are some exemptions. So if your organization is a public authority, you're exempt. And also if the processing is not it's not excessive, so it's only occasional. It's low risks to the data protection rights of individuals. And it's as I said, it's not large scale, so it's infrequent, low risk, and there's not very much of it. Then you're also exempt.
Andy, I've got a question. This question's actually from me. So do Risk Crew need a European representative? We have customers in the EU. We also have probably 1,000 contacts on our database in the EU that we send occasional marketing emails to. We generally only have their work email addresses in our CRM, but do we need a representative?
Yeah, I probably should have told you, Nick. It's something, as soon as this became apparent, there's something I looked into last week. No, we don't.
We don't.
That is, the processing we do is very occasional.
Yeah.
We are not continuously processing this information. It is not a large volume of data.
Yeah. And we've got no medical details or special category data. It's
all we have is the contact information.
Yes.
Those people, and we're talking of the hundreds, probably what, 1,000 at most.
Yes, I think it's just under 1,000. When we did the risk assessment on this, it was just under 1,000. So
this is all low volume, low risk, and infrequent. So we are exempt. So does that reassure you?
It does. It will reassure me, and it will reassure our MD that we haven't got the cost of having to appoint a representative.
Good. So what I've got is 6 key actions here, which to become and remain compliant. Now, these have been put together looking at whether we become a third country and what you would need to do. But most of them, I'd say all of them, to be honest, represent good practice. So none of this will be wasted, even if we was to get an adequacy decision at the end of March. And what I'm going to do for the rest of this presentation is to dip into each one of these and just give it a bit more detail and flesh them out a little bit. Now, this is essential, absolutely essential. It's the most important one probably. It's essentially conduct an audit for EU personal data within your data sets. So it's basically reviewing all of your data sets, understanding what the data is, where it originated from. Does it contain EU personal data? What are you doing with it, and why are you doing that? Because at the end of the day, you have to understand your data, and especially where it comes to EU personal data. No, I can't emphasize enough about the time is right now, especially while we've got this grace period of considering the adequacy decisions to conduct audits for EU personal data within your data sets. I'd say that's the number one priority.
And I guess, Andy, as with all things information security best practice, if you're doing an audit and you discover data that you no longer need or have a legal requirement to store it, get rid of it. It's going to reduce your risk, and it may also reduce your requirements for compliance with this.
Yeah, to be honest, Nick, I think these type of audits are worth the wait and go, because you'd be amazed at how many times we've set about with an objective for an audit, but the data and data sets we've uncovered, which wasn't known about before the audit.
Yeah,
it saves, reduces the company's, the organization's risk to unlawfully processing data they didn't know about. Oh, sorry, wrong one. Right, the second action, if we become a third country, any transfers from the EU to here is now an international transfer of data. And the data subjects need to be informed of that data transfer. So there are several ways of doing this. If you've only got a few dozen people, emailing them individually or letting them know personally is not a problem. But if you've got 500,000 to several million, it's too cumbersome to try and address it individually. You've got to look at different ways of doing it. So this is why it's so important to understand the data set, to understand the number of data subjects you've got, where they're located, whether or not they need to be informed. Would it be better to put something on your website? Maybe the privacy notices need to change. Maybe consent forms need to change. So this only becomes to light after you've done your audit and identified the data sets and you know what you're dealing with. You've also got to assess the processing activities for any potential improvement. Basically, if you can stop doing it, then that gets rid of it. But also, one of the things we're seeing is an awful lot of data controllers are now looking to see whether or not they can outsource the processing to processors based within the EU. So it keeps all of the EU processing centralized in an EU territory, which sort of circumvents some of the issues that could be expected. A data processing impact assessment would be the way to go on this, because doing a DPI here is justified because the processing environment has changed. We've gone from being an EU member to now a third country, and new requirements come along. So DPI here will help you to understand just what are the security risks and what are the legal risks to the security and privacy of the data and how you're processing it. You may need to amend data processing agreements with data processors. Simply to make them aware, you may have to look at standard contractual clauses. The ICO has got several versions, or some versions, but the European Union is also coming out with some new ones. Essentially, you've got to look at all of your contracts for where you're a joint controller or where you have a data processor and any sub-processing contracts in place, just to make sure that they reflect our new processing environment of being in a third country. And then we get to this designate an EU representative. And this appointment, it's got to be in writing. Sorry, Nick, did you say anything?
No, sorry. I'm just looking through a couple of questions that have come through. I'll feed them in shortly, Andy. Sorry.
Okay, good. Yeah, you've got to appoint and identify your EU representative. If it's required, you do need one. And that representative will act on the behalf of the organisation regarding the EU GDPR compliance. And it will deal with any supervisory authority or data subjects in that respect. So they'll be the conduit for any subject access requests from the EU nationals. And they'll also be subject to any awkward questions from the supervisory authorities regarding your compliance or lack of it. Now, as I said, it could be an individual or a company or organization, but they have to be established within the European Union and must be able to represent the organization regarding your organization's obligations under GDPR.
Andy, if I could, I've got a couple of questions coming from the audience. First one, regarding exceptions to appointing representatives, are you able to expand on what occasional means? I presume that's in occasional processing.
Yeah, right. If you think of what they're looking at for large-scale frequent processing, so that would be happening probably weekly and with thousands to millions of records. So by that would be sort of a standard process that happens within your organization. Whereas infrequently is like we've said, the example that Nick gave, which we actually do, we occasionally run marketing campaigns, but they're infrequent. They're not occur every Monday, for example. We do them every 2 or 3 months. We're a one-off shot. That is very much infrequent, and it's a low volume thing with a low risk data. But if you're doing something which occurs very regularly, and by what I'm saying weekly or twice monthly, and it's a large volume of data, then you may well have you're very likely to fall into the category of needing a representative.
Well, I guess it's a bit of a grey area, Andy, because there's no explicit, processing above this amount of data you do, below this amount of data you don't. It's not that explicit.
There is no specific figures within the legislation, either the EU version, the original one, or the UK side, which gives you a guide. There's none of that. It just mentions in plain English, infrequent or large volumes. And it's up to you to make a judgment call on that, but you have to be prepared to defend your decision.
Right. Okay. Thank you for that question. And Sarah, you've just asked, is there a threshold? I hope that's answered your question. And one other question, Andy, regarding EU representative. If you have data on EU citizens in multiple European countries, do you have to appoint a representative in each country, or would one representative covering the whole of the EU be compliant?
Right. With the EU legislation as it is, it would agreed, sort of informally agreed that one person will cover the whole thing, but it should be based in your main sort of target territory. Let's say Germany, for example, if you're targeting the German EUs with products and services, you put it there. But an EU representative can represent you for all of Europe. But there are considerations that have to be borne in mind, like language, and there are regional variations between the GDPR implementations. So it may well be you might need one or more to cope with that, languages and different regional variations. It becomes a commercial decision, basically, and the skill sets available to you. If one law firm might have that covered, they might be experts in most of the European territories and be able to do it for you. It's on a very much on a case by case. You've got to look at what you're doing and what areas you cover and make a decision based on that.
Okay, thank you.
Now, I would rate this as just behind the very first activity in terms of importance. And it's establishing a data breach reporting procedure. And the reason why I believe this is so important is if you're processing EU data and you have a data breach, you have to act very quickly, and the people involved, because of timescales, will need to know what the responsibilities are and what you expect them to do. They've also got to have been identified so that everything goes as smoothly as possible. So verify EU country by country breach reporting procedures and contracts. You have those in place so you know who to contact. Stipulate to any EU representatives what their role and responsibility will be in the event of a breach. We've put a link in there for all of the EU supervisory authorities, and that's for each of the countries there. It's just a helpful hint there, but it's basically having this reporting procedure in place, because as soon as a breach occurs, the clock starts ticking, and the timescales you've got to be involved there. So we've got Articles 33 and 34 of the GDPR legislation, which come into play here. 33 sets out the duties in the event of personal data being exposed and whether a hack or any other kind of breach should be reported. Article 33 is reporting it to the relevant supervisory authority, whereas Article 34 is about notifying it to the data subjects. And I would mention that not all data breaches need to be reported. So your data breach reporting procedure should be able to help you make that distinction of whether or not you do need to report it to the supervisory authorities or indeed to the data subjects. One of the things that we're quite big on here is future-proofing your data protection compliance. And it's trying to remove it away from being a reactive sort of implementation where you constantly try firefighting, trying to get things done, dealing with data breaches. We want to increase the awareness amongst users of data security and data protection requirements. I mean, users are generally the first line of defense. If we can raise awareness with them, the organization's in a better place to protect itself and stop data breaches occurring. We want to be able to prevent human errors, so look at processes and systems and see whether or not any changes can be made there to improve them. You also need to understand what data sets you have, which brings us back to the first point of doing audit. Identify who you share the data with and why you do share it. And ensure that you have the correct contracts in place. I mean, contracts can go out of date, they need amending, they need to be kept up to date. and the need to reflect the processing environment we are currently in.
And Andy, all the things you've just talked about on this slide, this isn't specific to adequacy or dealing with data in the EU subjects. This is just data protection, business as usual. This applies to all companies. This is just complying with the UK Data Protection Act.
Absolutely. This is just best practice, trying to move us from a reactive setting into one where everything is ingrained there and everything just carries on normal. We don't have data breaches. We don't have exceptions. Everything just carries on. But if something does happen, and occasionally it might, we are well prepared to deal with it. So this is best practice. And all of this is valuable to organizations, regardless of whether or not we get any adequacy decision. So I've gone through quite quickly, but let's just sum it up where we are. UK EU transfers are okay for another 4 to 6 months, that there's no changes required. Everything's carrying on as normal. But I don't believe that the adequacy decision is guaranteed. I really think there is a very large potential for one not to be there at the end of 6 months. So,
Andy, can I just interrupt you? We've had a comment from one of our audience, Alan, which is appropriate. He's written here, now that we're a third country, UK surveillance regime in collaboration with the US makes us inadequate, as highlighted by a court ruling last week. Alan would suggest that the UK is at risk of being deemed inadequate by the EU much sooner than 6 months out, politics notwithstanding. Thanks for that comment, Alan.
Alan, you're quite right. The European Court of Justice ruled against the US as being adequate simply because of the provisions that the US Secret Service had access to the data. And that will come into the data board's assessment of the UK legislation. So it's an unknown as to how that will be interpreted. That there's a lot of infighting and discussion within the legal teams of the EU Parliament, government. Some don't agree with the decision that was made by the court, but that's all out of our hands, and all we can do is watch and hope. I think it'd be very prudent to assume we are going to be a third country and to take the necessary steps now, not to wait for the 6 months for it to be announced, but to take the steps now or start the process so that if we don't get it, we're in a very good shape. Your organization are all set up for it. If we do get it, that work's not wasted. You understand your data sets. Everything is there as it should be. All the documentation is up to right. Everything just carries on. The work isn't wasted. You're in a much better position, understanding your data, understanding your contracts or your privacy agreements. Everything is there. So it's good practice, and I think it's worth doing.
And as Alan's just popped up and said, where's it gone? Plan for the worst case, hope for the best. Couldn't have put it better, Alan. Thanks.
Yep. I quite agree with that one, Alan.
Okay, that's been fantastic, Andy. I think we've got a few. Could you just bump to the next screen? I think we've got a couple of questions. Oh goodness, can I find it? Hold on a second. That was in the chat. No, hold on. I've lost it. We've got a couple of. Here we go. Yes. May I just confirm that if all our customers are UK citizens, but their data is held in cloud storage in the UK, but our cloud storage is in the EU, can we take our foot off the panic pedal regarding a no adequacy decision? Andy. That's a bit optimistic, I think, or is it?
Right. No, panic is always good. It's always useful. But in this scenario, yes, you can. Now, one of the things that the UK government has done, and very graciously, is they have indicated that they are going to accept all of the EU's current adequacy agreements as their own. So it makes the from a UK perspective, we think the EU has adequate data protection laws to our own. So we can happily transfer data to and from the EU. Just looking at it from a UK one. So you, as a UK organization, processing UK data, but it happens to be stored on a server based in the EU, there are no issues there because we have an adequacy, well, the government has said we have an adequacy agreement with the EU, or we regard them as adequate.
Okay.
So you don't need to panic.
Good. Okay, good. And one more question. If I've interpreted this correctly, as a company, we do not deal with any, we don't have any European customers, so they haven't got any European subject data on their customer-facing side, but they do have a number of employees and contractors that are reside in European countries. What's the position there, Andy?
Right. We're all coming back to these thresholds again, which they've given us no value for. So we've got a number of employees. So it's a low number. We're talking maybe a few dozen at most. So the processing itself is going to be interesting because it'll all be HR, and it will be. You would need to understand the processing environment and what systems they use. It may be that these EU nationals are using a system which is actually based in the UK. So we'd need to make that. The first thoughts are no, they would not need EU representatives because the volume of data is so low.
So low, yeah.
The processing is going to be infrequent. But you would need to, because it's HR, there could be some very sensitive data involved. So you would.
So it's kind of risk-based. It's a risk-based decision.
Absolutely. Sorry, Nick, that was the words I was looking for. You take a risk approach to this, quantify the risks, quantify the data involved against the processing environment, and see whether or not it needs any additional measures, and then you then make the representation of whether or not it needs an EU member. I generally I'd say no because of the way HR systems are going at the moment. But I'd want more information before I'd really stick my flag in the ground and say yes or no.
Sure. Okay. Thanks, Andy. I think that's about all we've got time for. Sorry if we didn't get to your questions. We'll try and get back to you afterwards. Andy, could you just bump to the next slide? Of course, you are very welcome to contact Andy and I directly. You've got, or you'll be given soon, these slides. So you've got our contact details there, email and phone number. As I say, you can check out our services on our website, and our full back catalogue of all of the webinars that we've been running over the spring, summer and autumn are all available on the Risk Crew website. I would like to thank you very much for your precious time this afternoon. I hope it was useful. And if I could kindly ask you just to take 30 seconds after this webinar shuts down to just ask I think it's 6 multiple choice questions for your feedback on this seminar. So thanks again, and from Andy and I, it's good night.
Thank you very much.
Thank you.